Alberta's new traffic ticket system comes into effect on February 1st. Do you have the right to a fair trial? No. Are you able to question the police evidence? No. Are you presumed innocent until proven guilty? No. Do you have any rights at all? No. Has Casey Madhu become the Minister of Poetic Justice? Last week, it came to light that the Minister of Justice in Alberta received a distracted driving ticket last spring in Edmonton, and then he phoned the Chief of Police of the Edmonton Police Service to talk about it. It is reported that Justice Minister Madhu was concerned about racial profiling by the police officer, and he also disputed the factual basis for the ticket. Minister Madhu stated that the phone was in his pocket, whereas the police officer gave him a ticket, presumably for using or talking on his phone. So there was a factual dispute there. I, personally, am not much concerned about whether or not the Minister of Justice should be calling the Edmonton Chief of Police about a traffic ticket that he just received. However, the timing of all of this is amazing, as Alberta has an entirely new system of traffic offence enforcement that's coming into effect on February 1st, 2022, so Monday. As a thought experiment, let's go through the process that Justice Minister Madhu would go through if he was issued this same ticket on the 2nd of February, instead of last spring. The new system is established by the Provincial Administrative Penalties Act, referred to as PAPA. I've included a full text of the statute in a link below. It's administered by SafeRoads. My name is Tyson Dahlem, and my firm is Dahlem Criminal Defence. Like many other defense lawyers, I've been dealing with the SafeRoads system since it was brought into existence in December of 2020 for impaired driving. The system's terrible. These are the main features of SafeRoads. 1. Everything the police officer writes on the ticket is deemed to be under oath, and it cannot be disputed. The laws of evidence no longer apply. The statute specifically states that. 2. You have no ability to cross-examine the police officer or any other government witness. The right to a fair trial, or, well, really, a trial, no longer applies. 3. The hearing, which is in writing or online, must happen within 21 days. You better be organized and have the filing fee on hand. The citation also doesn't state on it that you also only have 7 days to appeal. The adjudicator must confirm the ticket unless you establish that one of the reasons for cancellation of the ticket exists. There is no presumption of innocence. You are guilty unless you convince the adjudicator otherwise, and you cannot cross-examine the police officer or otherwise test his or her evidence. The adjudicator cannot change the ticket penalty. The adjudicator cannot take your personal circumstances into account. There's no more talking to the prosecutor. There's no more telling your story to the judge. There's no more pleading guilty to a lesser offense. There's no more negotiating the fine. That's all gone. You are stuck with whatever the police officer gives you at the side of the road. You think you have rights, but you don't. You only have what Papa gives you, which is bugger all. The Charter of Rights and Freedoms doesn't apply to the SafeRoads process because in its administrative tribunal. So, here we are. On February 1st, 2022, at least as far as traffic enforcement is concerned, Alberta will become a police state, in which everything a police officer does is deemed by law to be true. The officer cannot have his evidence tested. It cannot be challenged. You are presumed to be guilty unless you can satisfy the kangaroo court that is SafeRoads that the ticket should be cancelled. So, Minister Madhu, on February 1, it will be impossible for any Albertan, including you, to raise concerns about racial profiling or, the facts of what happened on a traffic ticket because by law, the police officer is always telling the truth. Wow. It really is that bad. Tell your MLA what you think. This link goes to a list of all the MLAs.